think the session is for today is the decision on the two objections, the one of the defense and that of prosecution. Thank you.
Okay, good morning. Let's go direct to the decisions, and I'm going to read it out. On the 1st of September 2025, the President of the Supreme Court and the Chief Justice of the Judiciary of South Sudan constituted this special court to try criminal case number 1533 2025 for Nasser incident, March 2025, against accused person under sections 48, 50, 52, 61, 62, 65, 64, 65, 66, 67, 70, 71, 72, 75, 76, 206A and B, and 239 of the Penal Code Act 2008, and also sections 15A, B, and 16 of Anti-Money Laundering and Counter-Terrorism Act 2012, amended. On 22nd September 2025, the defense presented to the court an objection called preliminary objection. The title, Objections on Lack of Jurisdiction of the Special Court to try the first Vice President and the 7 others accused persons. That may be summarized as follows. Number 1, supremacy of revitalized agreement. And number 2, jurisdictional and procedural objection. Number 3, counter objection on the appearance of private advocates as part of the public prosecution attorney's team. As for the supremacy of the RI revitalized agreement, the defense cited Article 8.3 that says this revitalized agreement shall take precedence over national legislations and existing agreement to the contrary, and in the event that the provisions of national legislations or of previous agreement conflicts with the terms of the agreement, the provisions of this agreement shall prevail. And that the revitalized agreement 2018 provides under 5.3.1.1 for the establishment of hybrid court for South Sudan. This court is independent and established by African Union Commission to investigate and prosecute individuals bearing responsibility for violation of international law and applicable South Sudan laws, committed from 15 December 2013 through the end of the transitional period. Nasser incident is a ceasefire violation, and therefore it falls within the jurisdiction of the hybrid court. Article 17 of the Revitalized Agreement 2018 that should be adhered to. Read together with Article 5.3.1.2 and 5.3.2.2. In addition to Article 201A, 7A, B, and D of the Transitional Constitution 2011 as amended. Furthermore, the defense mentioned that Article 9(3) of the Transitional Constitution of the Republic of South Sudan 2021 as amended provides that all rights and freedoms enshrined in international human rights treaties, conventions, and instruments ratified by or acceded to by the Republic of South Sudan shall be an integral part of this bill. So, trial of the accused persons disregard and alter-verse and unconstitutional. The defense also raised an issue of jurisdictional and procedural objection on the constitutional immunity of the first vice president, citing Article 103, 104, 2 of the Transitional Constitution of the Republic of South Sudan, 2011, as amended. Read together with Rules 62 and 63 of the Transitional National Legislative Conduct of Business 2013 as amended 2021 that provides that the first vice president shall not be subjected to criminal proceedings while in office, except upon the removal of immunity by 2/3 majority of all members of the National Legislative Assembly, and in accordance with the Rule 62 and 63 that provides that the provision of 62 shall, with the necessary modification, apply in respect of the first vice president and vice presidents. This raises questions as to when does court become competent. It is when it is properly constituted as regards yes, it is properly constituted. The subject matter is within the jurisdiction of the court, and case is put before the court based on due processes of law. This court is defect in its competency, since the President of the Supreme Court has no power to establish it before establish it has no power to establish it before provisions of the Transitional Constitution 2011 as amended, Article 103, 104, 2, and provisions of the Transitional Legislature Legislative Assembly 2013 as amended 2021, Rule 62, 63 are adhered to, and also lack of resolutions that shall have been passed by the 2/3 majority of members of Transitional National Legislative Assembly as amended. The arrest and detention of the accused were carried out without due process of especially lifting of the immunity of the first vice president. And therefore, on the proceedings are unconstitutional, unlawful, and void. The accused person shall be immediately released, plus any other relief deemed fit by the court. The response of the prosecutions may be also summarized as follows. Number one, that provision of revitalized agreement 2018 and transitional constitution 2011 amendment number 6, 2020 limits jurisdiction of hybrid court to international law crimes and crimes under relevant South Sudan laws, including gender-based crimes and sexual violations, when and if established. There is no conflict between the revitalized agreement and national law in this case. The two are distinct. Number two, that it is only the president who is immune during his or her tenure of office, according to Article 103(1) of the Transitional Constitution 2011, Amendment number 6, 2020, and Rules 62 and 63 of the Transitional Legislation, Conduct of Business Regulations 2013, Amendment 2021. They deal with the removal if the vice president and not trial, dealing with the removal of the vice president and not trial of the same, since that does not override provision of the Constitution. Number three, that according to Article 123(e) of the Transitional Constitution 2011 as amended, the Judiciary Act 2008 Section 7F, and the Code of Criminal Procedure Act 2008, Section 16(4), give the President of the Supreme Court powers to constitute a special court to try any person accused under Chapter 5 and 6, inclusively, of the Penal Code Act 2008, and a written order for establishment of special court as required under Section 44 of the Code of Criminal Procedures Act 2008. Therefore, the special court has been duly constituted in accordance with the law, and it follows that the court is legitimate. Number 4, that the Minister of Justice has power under Section 45 of the Ministry of Legal Affairs and Constitutional Development Organization Act 2008 to engage any advocate outside the ministry whenever necessary. Each party stood its position in its response and comment to pleading of another. And according to that, point for discussion and determination may be summarized as follows. Number 1, supremacy of the revitalized agreement 2018 as embodied into the Transitional Constitution 2011 Amendment number 6, 2020. Number 2, President of the Supreme Court has no power to constitute a special court to try national incidents crimes. Number 3, immunity concerning the first Vice President was not lifted when he was arrested. Number 4, a special court established by the President of Supreme Court is unconstitutional. Number 5, that private advocates who are on the side of or within the public prosecution have no legitimacy and should be sent away. And the 2 advocates within the defense teams lack or have no license and should be told to go outside the court or sit with the audience over there. Now, it is evident from the submissions that main points for the determinations are to be discussed as follows. Number 1, reading warrant of the establishment of this special court and argument of defense and prosecution, the court believes that there is no overlapping of jurisdiction between its competency and the one of hybrid court, for it tries offenses committed in Nasser incidents in March 2025, and that hybrid court have jurisdiction within with respect to genocide, crime against humanity, war crimes, and other serious crimes under international law and relevant laws of the Republic of South Sudan, including gender-based crimes and sexual violence, as provided for in the Transitional Constitution of the Republic of South Sudan, 2011, Amendment number 6, 2020. The Constitution made it clear that the hybrid court shall be independent and distinct from the national judiciary in its operations and shall carry out its own investigations. The hybrid court shall have primacy over any national court of Republic of South Sudan, of course, when a conflict of law arise. So, the hybrid court has jurisdiction to investigate and prosecute in respects with individuals who violated applicable laws of South Sudan, which are relevant according to Article 5.3.1 and 5.3.2, of the Revitalized Agreement of 2018. It is obvious now that those applicable laws of South Sudan and its other relevant laws have not been identified or named in the Revitalized Agreement on the resolution of the conflict in the Republic of South Sudan in 2018. It follows that failure of the Revitalized Agreement itself to specify, those applicable South Sudan laws and relevant laws of Republic of South Sudan made it difficult to understand the specific jurisdiction of the hybrid court itself in regards to the laws of the Republic of South Sudan, which fall within its jurisdiction, domestic laws. The hybrid court for South Sudan have not yet been established, and it is not clear when it will be established. National courts of South Sudan are operating and exercising their constitutional mandate according to the provisions of Article 122, sub-article 1 and 2 and 4 of the Transitional Constitution 2011 as amended, as long as they have not been suspended or withheld from doing their work by the hybrid court, which is in actual fact is not existing, since the national and hybrid courts are independent according to the provisions of the Article 5.3.2.2 of the Revitalized Agreement 2018. Those special courts enjoys jurisdiction to try this case according to the Constitution 2011 as amended. Number 2, as for the jurisdiction and competency of the President of the Supreme Court to constitute a special court to try and answer incidents, offenses, the law is clear that he or she has the power, bearing in mind the separation between hybrid court and national courts, as stated above. To explain, the President of Supreme Court of the Republic of South Sudan established Nasser Special Court according to provisions of Article 124, 122, 4, 126, 2, G, 3, and 127, 1B of the Transitional Constitution 2011, in addition to the provisions of Section 16, 4, and Sections 44 of the Code of Criminal Procedure Act 2008, and Section 11, 3, 7F of the Judiciary Act 2008. Therefore, the court has jurisdiction and competence to try the accused persons, since the wordings in the Revitalized Agreement 2018 and Transitional Constitution 2011 Amendment number 6, 2020 says that the word that's from 15th December so through the end of the transitional period is not meant to help or to hold back states' hands in addressing crimes, even if the hybrid court is active. The national courts have the jurisdiction and powers to prosecute offenses in the territory of the Republic of South Sudan. Therefore, it is the evidence that is the evidence that is the sticky yard to prove whether the subject matter of the trial belong to the hybrid court or national court. Number 3, concerning the lifting of immunity of the first vice president raised by the defense based on Article 103, 102 of the Transitional Constitution 2011 Amendment number 6, 2020, and Rule 62 and 63 of Transitional National Assembly Conduct of Business Regulations 20 Amendment 2021, which provides that the first vice president should not be subjected to criminal proceedings while in the office, except upon proper removal of the immunity by a resolution passed by 2/3 majority of all members of National Constitutional Assembly. The prosecution replies to these claims in their submission. In pursuant of Article 106, 106, 104, 103, and 102, the Transitional Constitution 2011 as amended, and provisions of 62, 63 of the National Assembly Code of Business, Article 1031 confers constitutional immunity upon the President of the Republic of South Sudan only. And Article 4, 1042 of the Constitution is dealing with appointment and removal of the first vice president of the first vice provision did not expressly or directly mention immunity of the first vice president and other four vice presidents. As for the provisions of rules 2 to 3 of conduct of business stated above deals with impeachment of the President of the Republic. And Rule 63 of the same deals with the removal of the first vice president and the four vice presidents. The two rules cited by the defense do not talk about constitutional immunity of the first vice president, because the constitutional immunity is created or granted by the Constitution as the supreme law of the land in the hierarchy, according to provisions of Article 3(1) of the Transitional Constitution 2011 as amended, which reads, this Constitution derives its authority from the will of the people and shall be the supreme law of the land. It shall have a binding force on persons, institutions, organs, and agencies of government throughout the country. Therefore, provisions of the National Assembly Code of Business 2013 as amended is a subsidiary legislation. It governs the conduct of business of the Assembly, which is subordinate to the Constitution 2011 as amended. And therefore, it doesn't create or grant constitutional immunity to anybody in the country. On the contrary to the Constitution, for the above mentioned reasons, the first vice president does not have constitutional immunity. According to the provisions of the Transitional Constitution. Therefore, the objection is rejected. Number 4, whether the special court established to try Nasser incidents is unconstitutional or constitutional. The Transitional Constitution 2011 Amendment number 6, 2020 says Judicial Services Commission shall undertake appropriate judicial reforms and restructuring of the judiciary during the transitional period. But the structure of the judiciary remains as it is under Article 123 of the Constitution above. Other courts and tribunals are part of the structure of the judiciary as provided for in Article A of the stated Constitution. Section 16 of the Code of Criminal Procedure Act 2008 provides for special courts, and it's specifically subsection 2 of the above provides that the President of the Supreme Court may convene a special court to be presided over by a High Court judge or any other senior judge, to be assisted by 2 accessories for the trial of tribal or sectional conflict and dispute involving capital offenses. Reading those provisions with the Judiciary Act 2008, you can say this is special court for Nasser incidents is constitutional and therefore has the competency to try the case as stated previously. Number 5, advocates here and there. Both parties to the case objected to certain advocates found within this or that team. Prosecution and defense. Prosecution's objection is that Advocate Deng, John Deng, and Warnyang shall not be allowed to be within the defense team because they did not renew their license according to the law. Advocate Act 2013. Failure to renew the license at the end of January every year, the license shall be deemed to have been suspended. The defense is not denying that, but saying they were deliberately denied to do so by the Bar Association. Since advocates are tasked to defend legal and interests of their claims, to prevent injustice as guaranteed in the national and international instrument, the defense praised the court to reject prosecution objection, considering the period from January, from the end January up to now. It is a long time. The advocates in question would have tried possible means to renew their license, including going to the court to settle the matter. Appearing before courts without valid license violates Section 26 of the Advocate Act 2013. It follows that joining defense team without informing or even taking permission from the court may not be upheld, since it is a constitutional requirement under Section 136(2) of the Transitional Constitution 2011, as amended, among others. The advocates shall observe professional ethics. The only way now for them to rejoin the team is to remedy their position by using Section 102 of the Code of the Criminal Procedure 2008 and seek out sanction of the President of the Supreme Court to appear before this court. As for the private advocates with the prosecution team, defense objection has no merit, simply because it is obvious from Section 45 of the Ministry of Legal Affairs and Constitutional Development organization that the minister may engage advocate or make use of legal expertise from outside the ministry whenever necessary. This is his or her discretion powers. Therefore, the objection is refused and the decisions or the orders of the court are as follows. Number one, objections of defense teams are overruled. Advocates Deng John and Kir Warnyang are ordered to leave defense team and seek sanction of the President of the Supreme Court to return back. Private advocates within the prosecution team are allowed to continue. Thank you. Sit down and finish.